I'm an attorney at the Lawyers Committee for Civil Rights in the San Francisco Bay Area. And along with John and our colleagues at Latham and Watkins, we are counsel for the plaintiffs in the San Francisco lawsuit Coalition on Homelessness versus San Francisco. Lawyers Committee also represented a group of approximately 30 San Francisco-based civic organizations, as well as some current and former San Francisco officials in a friend of the court or amicus brief before the U.S. Supreme Court in Johnson v. Grants Pass, which we'll talk about today. Next slide, please. So before we turn to the U.S. Supreme Court case, we want to start by talking a little bit about the case here in San Francisco, the Coalition on Homelessness versus the City of San Francisco. In September of 2022, a group of unhoused people and the Coalition on Homelessness, represented by the ACLU of Northern California and Lawyers Committee, sued the City of San Francisco for unlawfully citing and arresting unhoused San Franciscans for violations of anti-homeless sit-lie laws when there was no shelter available to them, and for destroying unhoused people's survival gears, things like their identification, medication, laptops, and cell phones. We filed this lawsuit based on years of evidence that despite having policies that promised a housing-first approach, in practice, San Francisco was regularly citing or arresting or threatening to cite or arrest unhoused people for simply existing in public, even when there was nowhere else for them to go. The lawsuit was also filed based on ample evidence that San Francisco routinely destroyed the belongings of unhoused people in violation of its own policies governing the handling and storing of unhoused people's belongings. These practices were contrary to San Francisco's own policies and were unconstitutional and harmed countless of unhoused people and made it all the more difficult for unhoused people to exit homelessness, exacerbating instead of helping the street homelessness crisis. In December of 2022, shortly after the lawsuit was filed, a federal district court issued a preliminary injunction barring the city from citing or arresting people without first making a real specific offer of shelter or ensuring that the person had access to shelter or housing. The injunction also requires the city to follow its own policies regarding the handling and storing of unhoused people's belongings. The city appealed the court's decision to issue a preliminary injunction, and in January of this year, the Ninth Circuit affirmed the injunction, upheld the preliminary injunction, affirming the trial court's decision that San Francisco likely violated the constitutional rights of unhoused people by criminalizing their existence. The case is set to go to trial in May of 2025. Next slide, please. I want to spend a little bit of time talking about the evidence in the case and the evidence that was brought before the court in support of the preliminary injunction. The evidence shows that all told, in a 3-year period before the lawsuit, the San Francisco Police Department cited or arrested approximately 3,000 homeless residents for sit-lie or lodging offenses, and the city could not show that those thousands of individuals had access to shelter before they were cited or arrested. These 3,000 citations or arrests include over 350 citations or arrests for violations of the state anti-lodging law and over 2,600 citations or arrests for failures to comply with police orders to vacate or move along from where people were sitting or lying or sleeping. The city also conceded in court that the city is thousands of shelter beds short. It reported being 2,674 beds short in 2021 in the lead up to the lawsuit. And it's also important to know that the city conceded that at the time the lawsuit was filed, there was no voluntary means for individuals to seek shelter on their own. The shelter wait list, the same-day shelter lines, and other mechanisms for unhoused people to directly access shelter were ended at the onset of the pandemic and had not been restarted at the time the preliminary injunction was being litigated. This means that many of those thousands of people who were cited or arrested or threatened with citation or arrest were threatened with criminal enforcement even when they had no means of accessing shelter on their own. Since the preliminary injunction was issued, the city has reopened the shelter waitlist system. And when I checked last night, the waitlist was over 100 people, which just underscores the scarcity in the system and how there's simply not enough shelter to meet the needs of San Francisco's unhoused residents. And it's important to also note that when in support of the preliminary injunction, plaintiffs brought before the court evidence that the city continued to conduct encampment resolutions and sweeps, even on days when there was little or no shelter to be offered and without the staff to offer such services. And so based on this evidence, the court issued the preliminary injunction, barring the city from citing or arresting individuals without first confirming that they did have access to shelter or housing. Next slide, please. The preliminary injunction also addresses the city's handling and storage of unhoused people's belongings. And again, the evidence in the case showed that in a 6-month period between January and through June 2021, the city created only 195 bag and tag records. These are the records that document the seizure and storage of unhoused people's belongings. But in that same 6-month time period, the city displaced over 1,200 unhoused residents by conducting up to 83 formal encampment resolutions or HSOC sweeps. And so that disparity between over 1,000 people displaced, over 83 sweeps, and yet only 195 bag and tag records was part of the evidence that showed that the city was not, in fact, following its own policies around storage and handling of unhoused people's belongings. This court also noted that the plaintiffs had documented dozens upon dozens of incidents of the city destroying everything from prosthetics to cherished family belongings. And each of those instances of property destruction makes it harder for people to exit homelessness, makes it harder for people to take the steps that they need to do to get off the streets and back into housing. Next slide, please. So I want to talk a little bit about what the preliminary injunction that's been in place since December 2022 does and does not do. So as a reminder, the preliminary injunction has 2 parts. The 8th Amendment part, which prohibits the city from arresting or citing people for certain anti-lodging laws, unless it is first made a specific offer of available shelter or otherwise determined that the person has access to shelter. And there's also the 4th Amendment part, which requires the city to follow its own policies around handling and storing unhoused people's belongings. That's what the preliminary injunction requires the city to do. It's also important to remember what the preliminary injunction does not do and does not cover. Under the preliminary injunction, San Francisco can enforce all of its health, accessibility, and public safety laws to address homeless encampments. And indeed, we have seen during the course, since the injunction has been put in place in December 2022, the city has continued with its encampment resolutions throughout the city. This injunction also allows the city and does not prevent the city from offering services such as housing and shelter and other treatment options to unhoused people. And we know that those services are unfortunately sorely lacking, which is part of the basis for bringing the lawsuit. And finally, the injunction does not prevent the city from clearing encampments once it has made a specific offer of actually available shelter to the individuals residing in that encampment, or otherwise ensuring that those individuals have access to shelter or housing. And finally, it's important to note that the injunction does not apply to people who do have access to shelter or housing. There's nothing preventing the city from engaging in criminal enforcement against individuals who do have some other access or form of shelter or housing. And I'll turn it over to my colleague, John, to talk a little bit about the case before the U.S. Supreme Court.
Hi, folks. I had the opportunity to go to DC to hear this argument. Ironically, that involved essentially sit, lie, or sleeping outside for 12 hours before the argument in order to get a spot, but wanted to pass along our impressions of the case so far. So Grants Pass v. Johnson concerns the city of Grants Pass challenge to a Ninth Circuit decision, which found that their ordinance was unconstitutional as it relates to unhoused folks and the Eighth Amendment's prohibition on cruel and unusual punishment. A case you all are probably have heard a lot about is also, of course, Martin v. Boise, which predates Grants Pass, but the issues were fairly similar. So Grants Pass is essentially a small community. I think it's like 40,000 folks in Oregon, close to the Oregon-California border, and they had an ordinance that it was styled as an anti-camping ordinance, but they defined camping as using any type of bedding. So essentially, it subjected people who were sleeping outside with using something as little as a blanket that subjected you to citations, fines, and eventually arrest and potential jail time. So I think that's critical to understand that these ordinances um, um, uh, very specifically target actions that are essentially human needs. I think if we can go to the next slide, a good quote from Justice Sotomayor highlights this. And so this is Justice Sotomayor asking the attorney representing Grants Pass is, what's so complicated about letting someone sleep with a blanket if the outside in the outside if they have nowhere else to sleep? The laws against defecation, the laws against keeping things unsanitary around yourself, those have all been upheld. The only thing the injunction does is say that you can't stop someone from sleeping in public without a blanket. So, and this really goes to the heart of a lot of what these ordinances do and don't do. The city of Grants Pass and other jurisdictions have often cited these ordinances as tying their hands in terms of being able to address, health and safety issues and the like. But as Justice Sotomayor pointed out, all those laws are have been upheld and are reasonable uses of a state's police power to regulate things like health and safety. But again, these ordinances, and specifically the ones that Grants Pass, were essentially about prohibiting sleeping outside when you have no other place to be. So one of the things that often came up in the oral argument is the reasoning behind these ordinances. And if you can go to the next slide. This is a quote from the record that came up during the oral argument, which just comes from the then council president of Grants Pass, explaining the basis for why they had these ordinances, which was, the point is to make it uncomfortable enough for them in our city so that they will want to move down the road. So again, the express purpose of these ordinances is to supposedly address homelessness by essentially shifting it to neighboring jurisdictions and the like. It's essentially banish folks from the community. Of course, in Grants Pass and elsewhere, unhoused folks are generally from the community in which they reside. And so it was really about pushing their own citizens elsewhere. And of course, the logical conclusion of this, if Grants Pass were to be upheld, was pointed out by Justice Sotomayor. Again, I think she asked, well, what will happen if every city that lacks compassion does what Grants Pass does and prohibits folks from sleeping outside? Are folks essentially supposed to kill themselves from lack of sleep? Was a good paraphrase of her question, which really gets to the heart of the issue here. So next slide. So some of the other key issues that were raised during oral argument that we're going to discuss in a little bit more detail were this dichotomy difference between status versus conduct. How the basis for that distinction in a case called Robinson v. California from the 1960s. And also some of the things that you may have heard in the oral argument is pre-enforcement versus post-enforcement challenges and what that looks like and the ramifications of that. Of course, if you didn't have the opportunity to listen to oral argument, it is available online, and it's 2 hours long, but it's certainly worthwhile to give a listen to hear some of the questions that were raised there. So next slide about status versus conduct. So the vast majority of the oral argument was focused on the line between what is someone's status versus what is conduct, and to what extent you can criminalize status versus one's ability to criminalize conduct. So status it's a state of being, that is generally inherent to a person. It doesn't necessarily need to be fixed. This could be, one's marital status. You could you're single, you have a spouse, that could change, but it's part of who you are. Obviously there's race, nationality, gender, whether or not you have a disability or a medical condition and your age. And generally speaking, in the legal context, a person has protections based on their particular status. Now that's compared to conduct, which is essentially behaviors, your actual actions that you actually have control over and you can do and you can or not do and you refrain from. And conduct can be criminalized. It can be deemed lawful or unlawful, meaning that you can be punished. You can potentially be cited and arrested for it, depending on the nature and context in which it occurs. And so the justices repeatedly asked whether or not homelessness is a status, and whether or not the ordinance here was criminalizing status versus the conduct. The city's position was essentially they were not criminalizing status, they were criminalizing conduct, the conduct of using a blanket to sleep outside. And the city also really pushed back on this idea of whether homelessness is a status at all. But here you'll see Justice Kagan suggesting that homelessness is, of course, a status. It's a status of not having a home. The city, and so essentially what the unhoused folks in Grants Pass were arguing is that this ordinance did indeed criminalize status of being homeless, because being homeless necessarily entails needing to sleep. So there is no real difference between criminalizing being homeless and sleeping and just being homeless, period. Other justices noted that it seems to be the equivalent of criminalizing homelessness while breathing. Essentially, again, if you add this biological need to live, that really doesn't change the calculus of whether or not something's a status versus a conduct. There are other questions of whether or not, for example, well, something like being a bank robber a status or something along those lines. But again, one can be, the act of robbing a bank certainly is conduct that one can refrain from and has control over, and could therefore maybe be subject to and is subject to criminalization. So I would go, if I can go to the next slide, we can talk about Robinson, California, which gives us concrete example of this and lays the foundation for what was spoken about at oral argument. So the case that was probably spoken about most is this Robinson v. California case from the 1962, and in which California's health and safety code essentially made it unlawful to be addicted to drugs, to have drug addiction. That is not about selling narcotics, using narcotics, possessing narcotics, but merely just being addicted to narcotics. So Robinson was after police officers noticed track marks and alleged track marks on his body. He was arrested, convicted of being addicted to drugs, and he challenged this as being a cruel and unusual punishment, which comes from the Eighth Amendment. The Eighth Amendment, again, prevents jurisdictions from having cruel and unusual punishments. And often the discussion about the Eighth Amendment is that it regulates the types of punishment that individuals could be subject to, whether that be, the conditions of confinement to how individuals are executed in, for example, death penalty cases and the like. But Robinson v. California also noted that there are instances where it's not just about the punishment itself, but it's also substantive what can be actually criminalized, where no punishment is really appropriate, in part because, for example, the punishment is completely disproportionate to the crime here. And suppose a crime in the Robinson v. California case was was drug addiction, just the status of being addicted to narcotics as opposed to individual conduct or specific conduct. So the question is whether or not this therefore applies to the status of being homeless. And of course, in one of the positions that the ACLU and others took was that certainly not only because it is so disproportionate to the crime, and again, the crime here in Grants Pass was essentially the crime of being homeless, of using a blanket when you had nowhere else to be, is that any type of punishment there is so disproportionate that it shouldn't be subject to any punishment based on the Eighth Amendment. Next slide. So one of, if that wasn't maybe confusing enough, one of the terms that you might have heard come up a lot is this distinction between pre-enforcement versus post-enforcement, the types of challenges that can be brought pre-enforcement versus post-enforcement. And also, if you heard the phrase a necessity defense that came up a couple of times, it relates to this. So a pre-enforcement challenge, which is what Grants Pass is and what the San Francisco case is, attempts to prevent cities from enforcing its anti-homeless laws under certain conditions. For example, if an individual doesn't have access to shelter. Before those laws can be applied to specific individuals. So it does aim for a larger amount of relief and does not concern protecting just one particular individual. So like in San Francisco and like in Grants Pass, it is an attempt to ensure that to prevent the police from targeting unhoused folks, citing them and arresting them before it begins throughout the entire jurisdiction. There was a suggestion that whether or not post-enforcement challenge is more appropriate, or perhaps whether or not there should be just a necessity defense. So a necessity defense, to the extent that it exists, essentially puts the burden on a specific individual to raise this idea that they had no choice whatsoever. They had no really other option, and essentially were compelled to violate the law potentially. The problem with this approach is that it would come afterwards, and the onus would be on the individuals, and it would come after an individual has already been cited, they've already been arrested, they possibly have already been given a warrant, and also been jailed. So it isn't particularly effective in cases like Grants Pass and in San Francisco. And pre-enforcement ones make a little bit more sense, make a lot more sense, I should say, because there's already an established history of these jurisdictions, going out of their way to enforce these laws. And homeless individuals are clearly still going to be subject to them moving forward. So that explains why the post-enforcement version of it doesn't really address the harms that unhoused folks are facing. Next slide, please. In which I will pass over to Nisha to cover the potential outcomes of Grants Pass on San Francisco.
Thanks, John. So before we turn to San Francisco, I just want to talk a little bit about what the potential outcomes are for the Supreme Court's decision in Grants Pass. So the slide covers kind of what we think are the kind of 4 potential outcomes here in broad strokes. I won't speculate about what exactly the Supreme Court will do, but the first potential outcome is that the Ninth Circuit's decision is upheld, that the Ninth Circuit's ruling in Johnson v. Grants Pass remains the law. And this would kind of leave the legal landscape in place as it's been in the Ninth Circuit, and also extend the Eighth Amendment protection under the Cruel and Unusual Punishment Clause against punishing and criminalizing homelessness to the rest of the country. The second potential outcome is that the Ninth Circuit decision is overturned, and this would mean that the Supreme Court would reverse the Ninth Circuit's decision entirely. This would essentially mean that the Cruel and Unusual Punishment Clause does not prohibit criminalizing homelessness, which of course would be a significant change to the established precedent here in the Ninth Circuit. Third, the Supreme Court could certainly issue a narrower ruling. As John mentioned during oral argument, there was some discussion of potential narrowing principles. And so it's very possible the court could issue a decision that narrows the protection against criminalization of homelessness without doing away with it altogether. And then finally, the Supreme Court could decline to rule on the substance of the case at all. The plaintiffs in Johnson v. Grants Pass, the unhoused people who brought the lawsuit, had argued back when the court was considering whether it should even take up the case, that this case was a poor vehicle for Supreme Court review, meaning that it was a poor case for the Supreme Court to decide these issues. And part of the reason they argued that is that Oregon has already passed a state law that prohibits cities like Grants Pass from imposing a total ban on sleeping and staying warm in public space when there's no alternative shelter. And therefore, the plaintiffs argued that there was no need for the Supreme Court to weigh in on the local ordinance at issue in Grants Pass when the Oregon State Legislature has already spoken and taken some action. And we heard some discussion of this Oregon law during the oral argument, so it's possible the Supreme Court will use that off-ramp and pass on deciding the legal question of whether the cruel and unusual punishment clause applies here and how. Next slide, please. And finally, I think it's also important to remember that irrespective of what happens with the Supreme Court decision in Grants Pass, our case here in San Francisco is going to move forward. And it's going to move forward for a few reasons. The first is that only one of the 13 claims that we currently have in our San Francisco case comes directly from Grants Pass. The remaining claims related to the destruction of unhoused people's belongings, the city's failure to make reasonable accommodations for unhoused people with disabilities, and the question of whether the way in which the city clears encampments actually unlawfully endangers the lives of unhoused people. All of those legal questions are not implicated by the Supreme Court's ruling in Grants Pass, and so will be unaffected by whatever the Supreme Court decides in June. And then it's also important to remember that the Supreme Court's decision in this case is going to, as I mentioned, come out in June. And so we'd expect to understand after that what its implications are going to be for our Eighth Amendment claim for the preliminary injunction and for other cases brought under this doctrine after that point. Next slide, please. And I think that brings us to the Q&A portion. So I'll maybe turn it, let me see if I can see in the chat if there are any questions. John, would you like to maybe take the first one and then we can go from there?
Let's see here. Yeah, so one of the questions is, if the Supreme Court reverses the decision and the Eighth Amendment claim is removed from the San Francisco case, how would that impact the current preliminary injunction? So I think that would be similar to what Nisha just presented with regards to the impact on our case. But the preliminary injunction was based on two claims that we had. It was based on the Eighth Amendment claim and a Fourth Amendment claim. And so if the Supreme Court were to reverse, then certainly the city of San Francisco would seek to have the Eighth Amendment component of the preliminary injunction removed. The Fourth Amendment conversion of it, which ensures that San Francisco abides by its own policies with regards to bag and tag and ensuring that they don't destroy people's belongings, would remain in place, and the rest of the lawsuit would still continue.
Thanks, John. I can take the next one. The question is, if Grants Pass is reversed, can San Francisco begin enforcing anti-homelessness laws without first making genuine offers of appropriate shelter? And would the city be permitted to issue citations without offering shelter? So I think the premise of this question is that the Supreme Court reverses Grants Pass entirely, and therefore there is no Eighth Amendment cruel and unusual punishment clause protection against criminalizing homelessness without first making sure that the individual has access to shelter. I think in that scenario, it's also important to remember that San Francisco has its own policies, including a voter-adopted ordinance that require it to make offers of shelter prior to clearing encampments. And so even if the Eighth Amendment protection falls away, we'd expect to see San Francisco following its own policies the policies that it tells its taxpayers and its constituents that it follows, and abiding by this requirement that is in its own policies to make offers of shelter before clearing encampments or reaching for tools of criminalization. It's also important to remember that, as Justice Kavanaugh himself noted during the oral argument, criminalizing homelessness is not a solution to homelessness. All of the data, the literature, social science shows that the solution to homelessness is providing homes. And the investment in affordable housing that's necessary to solve our homelessness crisis should be San Francisco's focus, and they should not be reaching for tools like criminalization, even if Grants Pass is overturned, because we know that putting someone in jail or issuing them fines that they can't pay is not going to help them move off the streets and into housing. And so I think it's really important to ensure that San Francisco, irrespective again of what happens in Grants Pass, even if the decision is a reversal, ensure that San Francisco follows its own policies and invests in the solutions that it tells its constituents that it believes in when solving the homelessness crisis.
Yeah, and I would just add that I think it is concerning that if Grants Pass were to be reversed, as Justice Sotomayor noted, then we may just have a like an arms race to the bottom of trying to make unhoused folks as uncomfortable as possible. But our hope is that there will be other protections that we can still rely on, and of course the city has its own policies as well that they claim that they are abiding by. Looking at another question is, Mayor Breed announced that the number of tents in San Francisco has decreased since the city was able to set up enforcement after the Ninth Circuit clarified the preliminary injunction. Is this an accurate assessment? I think a couple things. My response to that is I haven't, I can't vouch for the, the numbers that the city presented. What I can note, though, is the city has alleged that the numbers of encampments have gone down since our lawsuit and the preliminary injunction. So that seems untied to the supposed clarification that the mayor is citing. And I think it's a little peculiar for the city to suggest that it stems from this quote unquote clarification, because that clarification came from the Ninth Circuit rejecting their motion. It was essentially a denial in which it recognized that all parties recognize that the Martin v. Boise protection only applies to individuals who don't have access to shelter. That's in the Martin v. Boise decision itself. And so, and therefore doesn't apply to individuals who, for some reason, were to reject shelter to begin with. And then I'll also note, as Nisha just explained, a reduction in tents, while I think we all support, folks not having to be living outside, isn't necessarily, though, an indicator of whether or not homelessness is going down. And so that, of course, the solution to that is housing in and of itself. But again, we certainly encourage and expect the city should be offering appropriate services to individuals, including temporary interim shelter but also eventually long-term permanent affordable housing.
Thanks, John. The next question is, if the Supreme Court overturns Grants Pass, can we expect to see more arrests of unhoused people in California? Will this remove the incentive for cities to create more shelter? I think it's a great question. I think it speaks to what John was talking about a few questions ago, which is this kind of race to the bottom. And I think there is real concern and real risk that if the Supreme Court does away with this very basic protection against criminalization of homelessness, that we will see jurisdictions reach for this tool we will see an increase in arrests of unhoused people simply for being in public, even when there's nowhere else indoors for them to go. And I think one of the challenges, and this is to Justice Sotomayor's question, is, one of the challenges is that jurisdictions will be incentivized to pass more and more draconian laws designed to push people out of their jurisdiction, just get them out of sight, out of mind. And it really begs the question of where are folks supposed to go? And I think this is a good place to also raise the statistic that we cited in our amicus brief and others have raised as well, which is that the data suggests that, and the data actually suggests is the wrong word, the data shows that in many places, including Grants Pass and San Francisco, that folks who are unhoused and living on the street are from that community. They were housed in that community before they became homeless. So this narrative of the idea that people kind of come to jurisdictions to take advantage of services that are there, or take advantage of whatever kind of lax laws or anything like that, is really a false myth. The data is very clear that people become homeless in the jurisdiction that they're from. And so that's especially problematic then for cities to try and push out their own residents simply because they cannot afford a place to live indoors in the jurisdiction. And then to the question of whether it removes the incentives for cities to create more shelter, I think, again, I think that's true. I think if the Supreme Court does away with the very basic protection in Grants Pass, there is less incentive for cities to create shelter. But cities like San Francisco and others claim that they have a compassionate services first, housing first approach to homelessness. And so we'd expect that, again, even if that protection goes away, that cities are abiding by their own policies that are often voter enacted, the will of the people, and doing the things that the community wants to ensure that people have a place to go, have a safe place to be in shelter temporarily, and then eventually transitioning to permanent and more affordable housing. But of course, we know that where this protection, if this protection were to fall away, that there would certainly be potential problems with additional and more and more draconian practices.
Yeah, folks are still welcome to send in questions. I have another one, which is, can you talk a bit more about the problem with a post-enforcement approach to enforcing ordinances to curb street homelessness? So let me talk maybe a little bit of similarities between San Francisco and Grants Pass. Like I said, both of those cases are pre-enforcement challenges. So those are lawsuits to try to stop the jurisdiction from across the board enforcing its anti-homelessness laws against involuntarily homeless individuals, against homeless individuals who don't have any place to be because, for example, the jurisdiction doesn't have shelter or real alternatives. In both cases, and in other pre-enforcement cases, one needs to show that there is a likelihood that the city will try to enforce these laws. And in both Grants Pass and in the city of San Francisco, that record's very clear. In Grants Pass, they they have their own policy of essentially saying that they want to make people as uncomfortable as possible. They had a record of people being cited and arrested. In San Francisco, we have some of the very similar language and narratives happening here. And as Nisha cited earlier, we have examples of 3,000 citations and arrests, and we have clients who have had similarly citations and arrests. And so those citations and arrests and the potential for folks getting warrants or spending time in jail, that is punishment in and of itself. That happens pre-conviction. And so it's important to have a pre-enforcement challenge so that people aren't subject to those punishments, which can derail their ability to exit homelessness to begin with. A post-enforcement approach would essentially say, if an individual were to get cited or specifically arrested, then prior to them being convicted by a judge or jury, then the defendant, the unhoused person individually, we need to raise this defense that, there are different versions of this necessity defense, but like they essentially had no good alternatives. They had no real alternatives. Um, um, and uh, and it's unclear whether or not that even exists in a lot of these jurisdictions, and whether or not folks actually have the opportunity to really do so in a meaningful way. But that again only addresses individual circumstances, and also doesn't necessarily impact the citations with the civil citations that involve just monetary fines. It may not necessarily apply to that at all, which is of course still a punishment in our mind that is again entrenches homelessness and poverty as opposed to doing anything to alleviate it.
Yeah, I'll just add on that. I think, it's really worth underscoring just the practical challenges with this type of post-enforcement approach that was bandied about a bit at the court during the oral argument. I mean, what we'd be talking about here is that forcing someone to still be arrested, sit in jail for however long they're going to sit in jail for, and all of the knock-on effects that come from that with employment and their ability to maintain their belongings and their connections to the community. Imagine someone who's working but still unhoused, and how much even just a short jail stint could impact their ability to maintain their employment, and forcing them to wait until their case proceeds to court just to raise that necessity defense really is not a workable solution, not a practical solution. And it's why it's been so important in Grants Pass and in San Francisco to ensure that there is a pre-enforcement mechanism to ensuring that people are protected from criminalization of homelessness without having to endure much of the harms of criminalization before they're able to even raise this defense or raise this challenge.
One of the questions is, what would it take to settle this case against San Francisco? So I don't want to get into any type of settlement discussions between the attorneys and counsel. What I can just note is that we've previously taken the position and have informed the city, I think over a year ago, in terms of what important steps that the city could take to actually address homelessness, and that ranged from ensuring that there is access to SROs, supportive housing, that is laying empty right now. The vacancy rates for that are still pretty high. There's also a need for increased access to the shelter waitlist. Nisha mentioned earlier that San Francisco has opened up. It's not the same list that they had previously, and that not all shelters are listed, and same day lines to ensure that every bed that can be used is used. That is still missing, and there have been difficulties with regard to people accessing that wait list in and of itself. That is problematic. And another thing that's worth noting is that previously San Francisco, did do a better job of being able to provide individualized shelter opportunities. But as our evidence noted, that has plummeted during the period of time before our lawsuit. So I can't say again what it would take to necessarily settle the case right off the bat here, but those are certainly some better solutions than criminalizing homelessness.
So it looks like that's all of the questions that we have in the chat, but I want to give John and Nisha one more opportunity to add any final thoughts before we close the session. Or perhaps
I want to give you all more of your time back.
Okay, well, wonderful. Well, thank you everyone who attended. We really appreciate you taking the time out of your day. We encourage you to continue covering both cases, and I will follow up with everyone via email with a recording of the session. So thanks again, and I hope everyone has a good rest of their day.
Thanks,
And
Carmen.
thank you, John and Nisha.